Hey guys, this is John Watts. Thank you for watching this video. I think you'll find this very interesting if you are curious about the Fair Debt Collection Practices Act, the FDCPA. There will be three issues that we cover in this case, and this is from July 30 of this year. And the three issues involve what's called bona fide error, which is where the debt collector says, okay, I violated the FDCPA, but I should get off the hook because it was an innocent mistake and I had all these procedures to avoid it. And then the second issue will be when you get a validation letter, and sometimes it's called a 1692G letter after the particular section of the FDCPA, and then you request verification of that, what happens. And then related to that would be the third point, which is really the reason I'm bringing this case to your attention. The question comes up, you request that verification, and before the debt collector verifies or validates that debt, they report it to the credit bureaus. Is that a violation of the law? And so we'll address that in this case. So the defendant debt collector is a company called Rainmaker 3 Recovery, and the argument is that they violated the FDCPA with their credit reporting. So let's look at some dates because these will be significant. We have August 14, there was a collection letter, and this is on behalf of a doctor. And then less than 30 days later, on September 13, the plaintiff sends Rainmaker, the debt collector, a letter which the debt collector admits it received, requesting validation of the debt and requesting that the debt be flagged as disputed. So it's within that 30-day time period, so this would invoke that validation or verification under 1692G. And then what's this about, a couple months later, December 2nd, plaintiff gets his Equifax report and the debt's on there, but it does not indicate that it was disputed. And then finally in January, validation of the debt is provided. So we're going to go into the bona fide error defense here. And so the court's going to point out that this debt collector is pretty small, 3 employees. They use some debt collection software here. And so what happens when the debt collector received that validation request? So they pointed out that they noted in the software that there was an attorney representing the consumer. And that's significant. If you remember our videos where we go through the text of the FDCPA, if the debt collector knows that the consumer is represented by a lawyer, then they can only communicate with that attorney. And they noted that the debt was disputed. But there was a possibility that the collection agency failed to check a box that this is probably a typo here in Google Scholar, or maybe in the court's opinion. I'll just read it. Possibility that he failed to check a box that would have prevented the account from being reported to Equifax as disputed. I think this means as not being disputed. So in other words, should have checked a box saying disputed, and then when it gets reported to Equifax, it will be reported as disputed. That's the point here. And then at the end of the year, so this is after it's been reported to Equifax, but before the validation, so December 30, the collection agency notices file was reported incorrectly and the dispute box had not been checked. And then as he's looking back through it, he says, hey, I noticed we reported to Equifax November 30 without being flagged as disputed. I don't know if that was my error or software error. And so he corrected the error and deleted the report and then sent the validation or debt verification. Remember, courts use these words interchangeably. There is kind of a correct way of using this, but the courts are all over the board on this, so I'll use them interchangeably because that's how the courts do it. So the debt collector delivered the debt verification documents at the end of January. So we have summary judgment. And we're not going to go through all this very much, but the point of summary judgment is that you say no reasonable juror could rule against me. Well, if there are factual disputes that are important, then a jury has to decide that. Go back to the example I always use. Two people crash in the middle of an intersection, and Bob says he had the green light, and Susie says she had the green light. Well, one of them did, one of them didn't. And the judge can't decide. The judge is not in a position where she can go, well, I think I'm going to believe Susie. No, that's for the jury to decide. So let's get into the actual violation. So E8 is a section of the FDCPA that says you cannot report false information about a consumer to a credit reporting agency. And false information would include not marking it as disputed if in fact it's been disputed. And so the court starts off, look, it's undisputed that there was an error here. They failed to report the account as disputed. That's the basis of the claim. And so no dispute about that. What there is a dispute about is this bona fide error defense, and whether there's something that needs to be tried on that. In other words, do we need a jury to look at whether or not the debt collector gets the benefit of this bona fide error defense? So here's the text of it. May not be held liable in action brought under the FDCPA if debt collector shows by preponderance of evidence. That's just the standard in a civil case. So it's not a criminal, beyond a reasonable doubt. It's preponderance. So if you have the scales of justice, kind of think about, and they slightly tip in one party's favor, then that's a preponderance of the evidence. You could think of it as 50.1%. Okay, it doesn't have to be 99% or 90%. It's just slightly more likely than not. So if the debt collector shows that the violation was, and let's zero in on this, not intentional and resulted from bona fide error, notwithstanding the maintenance of procedures reasonably adapted to avoid such error. So if it's intentional, you don't get bona fide error. If it's a mistake, you might get it if you can show you've got procedures that are reasonably adapted to avoid that particular error. And so the court points out, hey, this is an affirmative defense. So affirmative defense means, hey, I may be guilty of what you're accusing me of, but here's why I win anyway. So, for example, statute of limitation is an affirmative defense. Say, I might have done the bad stuff you say, but you waited too long to sue me. And so whoever raises that affirmative defense bears the burden of proving it. So sometimes debt collectors will say, well, we have bona fide error, and you can't disprove our bona fide error. Well, I don't have to disprove your bona fide error. You, the debt collector, have to prove it. I don't have to prove a negative. I just have to say you violated the law, and then it's up to you to prove and convince a court or convince a jury that you have this affirmative defense. So now the court breaks it down into three parts here. Unintentional, result of bona fide error, which in a sense is similar, but there's a slight difference we won't get into in this case. And then number three, maintain procedures reasonably adapted to avoid any such error. And the court's going to focus in on this third prong. Did you have procedures reasonably adapted to avoid the error? And it says here in the case that's objective, fact-intensive inquiry that's normally left to the fact finder. So the fact finder is normally the jury. If a jury has been requested and will be in this case, then the jury decides that. The judge gives the law to the jury. The judge manages the case, so she makes sure that the rules of evidence are followed and things of that nature. But the jury decides what the facts are. Go back to my car wreck example. The jury decides, did Bob have the green light or did Susie have the green light? That's not for the judge to decide. Now, sometimes people file cases and do not request a jury, and then the judge will be the fact finder. So we call that a bench trial because there's no jury. You're just trying it to the judge who's on the bench, okay? And so when you see fact finder in a case, it's almost always the jury. And so here's a quote. The inquiry into whether a debt collector's procedures are reasonable is by its nature fact-intensive and should therefore typically be left to the jury. And this is an interesting thing here. The debt collector says, we don't know how the error occurred. And the employee says, maybe it was a computer malfunction. Maybe it was a software malfunction. Or maybe it was human error. It was me. I may have neglected to check the dispute box. And the court says, well, look, they do have oops, let me get the right one highlighted here. Does have a procedure for tracking the status of accounts that apparently depends on the software. And this guy said, we've never had these problems before, but the court says, well, we don't know, is this an industry-wide problem with the software? Is this sort of a known bug? Has the software been updated? Do you have quality control? What's your training protocols? We don't have that information. Remember, the debt collector has to prove this. And the court says, you're kind of self-serving speculation that maybe your failure to check the box could have been inadvertent. That's not good enough. And so the court kind of summarizes it and says, we don't know how this happened, or to what extent your procedures were reasonably designed to prevent errors, and not just errors in general. Like you can't say, we have a policy not to violate the FDCPA. Well, congratulations. That does you no good. Your policy as a debt collector needs to be specifically adapted to this type of error. So if, let's say that a debt collector calls a represented consumer. Well, again, you can't say, well, we have procedures not to violate the law. No, you need procedures to say, when we know that a consumer has a lawyer, here's how we prevent, and we'll anticipate what the possible errors are, and we'll make sure to prevent those. Or same thing here with credit reporting. And so we have even this quote here, a fact question exists as whether the uploaded Equifax resulted from software glitch or bona fide error. And so that's not going to be good enough. Now, maybe the judge should have ruled against the bona fide error because there really wasn't much evidence put forth by the defendant. They bear the burden of proof. But in any event, the court says the jury might well accept their bona fide error, question of fact. So I'm denying the plaintiff's motion for summary judgment. I've not gone back and read the brief, so I don't know if I would have done the same thing, but this is what the judge did. So here's where we get to the really interesting part of this. It's a 1692G. You'll remember that's a validation. And so what happened is, let me kind of set the stage. The lawsuit, the complaint, did not cite or explicitly refer to 1692GB. So the plaintiff says, I accidentally forgot to put that in my lawsuit. But look, we've been sort of litigating this, and so it's no big deal that I forgot to do that. And the court points out, well, at paragraph 12, you say the defendant has not responded to your request for validation, but that was actually incorrect because, let me get this, Rainmaker did validate the debt in January 2018. Now, the court notes that there is enough information in the complaint to support a claim under 1692G, but it wasn't actually stated in here. And so it says a complaint must still be sufficiently clear. And so the plaintiff, very smart, says, well, judge, allow me to amend my complaint. And the judge says, well, normally we'll allow you to amend your complaint except where it would not survive a motion to dismiss. And if it would not survive a motion to dismiss, we'll deny it. And some courts call this the futility factor. So they'll say, look, if it'd be futile for you to amend your complaint because you're just going to lose anyway, well, then we're not going to allow you to amend your complaint. And so the debt collector says it would be futile because they're protected by the bona fide error defense. Well, we've already kind of dealt with that. The judge has said that's going to go to a jury. And number two, this is the key part. the November 30 reporting of the debt to Equifax was not an action to collect a debt. So remember, and we talk about this in other videos, you get that 1692G validation notice, and then you dispute it and you request verification. The debt collector only has 3 options. It can do nothing. So it doesn't validate or verify the debt, but also doesn't collect. Or it can validate, verify the debt. And again, courts use these terms interchangeably, so I'm going to use them interchangeably. So number 1 is they can do nothing. Number 2, they can verify or validate debt. Number 3, they can get rid of the debt. They could have sent it back, in this case, to the doctor's office. But they did nothing until January 30. Remember, the validation request came in, I think, September 14 and was received on the 18th. Well, they waited, October, November, December, all the way to the end of January to actually verify the debt. So they would say, see, we chose option number 1. We did nothing. But the plaintiff points out, no. You reported me to Equifax after I sent you that dispute verification letter, and you reported it before you validated the debt or verified the debt. And so that's why we have here the collector saying, well, look, when I did that, when I reported it to Equifax, that was not collecting debt. I didn't take any action. So you lose. And so as I point out, the judge says, look, I've already said this bona fide error, that's going to go to the jury. So here's where it all comes down to. Whether reporting a debt to a credit reporting agency such as Equifax constitutes a debt collection activity. I'll give you a little side note here. We sued a major debt buyer because our client had been sued by them, settled his debt, and let's say it was $5,000, and he paid $3,000. And then a couple of months later, he notices on his credit report, that account is still on there showing a current balance of $2,000. It's like, well, wait a minute. I settled that debt. I owe nothing. If you settle a debt, you owe nothing. Assuming once you made the payment. And so we sued that company. Now, in that particular case, we also disputed it through the credit bureaus. It came back verified, so we had a Fair Credit Reporting Act claim and a Fair Debt Collection Practices Act claim. And this debt buyer, this debt collector comes in, and they just proudly announce to everybody, credit reporting is absolutely not debt collection at all. And my law partner and I are kind of looking at each other like, okay, do they think we're idiots? Do they not check and see? We've been doing this a really long time. We have sued this company dozens of times. And we teach on this around the nation. Like we know what we're doing with this. Why are they telling us this sort of absurd thing? And they were just so proud of this. Now, the case got resolved, and obviously they would not have resolved it if they really believed that. But they made that argument, and this is an important lesson because there is some court somewhere that has said something that's kind of crazy. Okay, and these debt collectors will take that one case, even though there's like 100 that go the other way, they'll say, see, this is the law. And they'll try and convince you of it. And particularly if it's a lawyer who has not really done this before, they'll say, look, here's the law, and we're going to come after you for sanctions if you don't immediately get rid of this case. And sometimes we still get that, which is sort of amusing. And, we say, okay, come after us for sanctions. And, they always back down because they know that they're wrong on it. So let's look at this. We have this very familiar thing that we've talked about in a bunch of cases. Here's the purpose of the FDCPA. Eliminate abusive debt collection practices. Ensure those debt collectors who don't use abusive debt collection practices are not competitively disadvantaged. And promote consistent state action to protect consumers. And you'll recognize this from our other case decision videos. It's a remedial statute construed liberally in favor of the consumer. And, construe the language broadly so as to affect its purpose. So the court says, look, this part is undisputed. September 18th, debt collector gets the dispute letter requesting verification. And then after that, so we have October 18, November 18, November 20, 2 months later, they send the reporting information to Equifax and did not verify the debt till January 2018. Plaintiff contends defendant's act of reporting, albeit automated reporting. Now, I don't know what difference that makes, but the defendant's saying, see, it's automated, like we didn't really try and collect the debt. Well, whether you do something automated or manually, it's the same effect. I mean, the credit report doesn't say, like, doesn't have an asterisk mark on it that says, by the way, this was automated reporting. All reporting is automated. But anyway, let me go back and read this. Plaintiff contends defendant's act of reporting, albeit automated reporting, to Equifax after plaintiff sent a dispute letter, but before the debt was verified, violated 1692G. And then they're going to start with the Sixth Circuit, which is the appellate court over this trial court or this district court. Dictates that each failure to cease collection activity without having validated the debt presents a discrete claim for violation of the FDCPA. This is important, usually for statute of limitation purposes. Maybe you sent a validation request and the debt collector called you. And then more than a year goes by, so you can't sue for that. But then 10 months ago, they sent you a letter. And so you sue them for that. Well, every time they break the FDCPA, that's a new violation. It starts the clock again, which is 1 year on statute of limitation. And the Sixth Circuit assumed without deciding that the reporting of a debt to a credit reporting agency like Equifax after validation has been requested constitutes collection activity. Now, how did they get there? Well, they referenced a Federal Trade Commission letter that gave the opinion, it's not binding, but gave the opinion that a debt collector reporting a disputed debt during the validation period is a, quote, collection activity. And so then we have this case against Midland Credit Management. And Midland Credit Management, Midland Funding, Encore, this is maybe the largest debt collector or second largest debt collector, debt buyer in the nation. And the court affirmatively held what that Purnell case that we just looked at assumed. Well, what is that? That reporting a consumer's debt to a credit reporting agency after the consumer requests verification, but before that's actually provided, constitutes a collection activity. And here's the language. I'll get this to highlight here. So while recognizing the FDCPA is unclear on the question, the FTC views reporting to a consumer reporting agency, and let me just stop there. Credit reporting agency, consumer reporting, it's all the same thing. It's just different words to describe the same thing. As a collection activity prohibited by 1692G after a written dispute is received and no verification has been provided. And the FTCPA explains the reality is that debt collectors use reporting mechanism as a tool to persuade consumers to pay, just like dunning or collection letters and telephone calls. And the court said, I'm not obligated to do this. This is what's called the Chevron Defense. Kind of a complicated thing when agencies make rulings. But for our purposes, the court says, but nevertheless, the FTC's guidance here is entitled to respect, and it has the power to persuade. And then the court, on its own experience, this is a great quote, noted that it has learned through its work on countless FDCPA cases that threatening to report and reporting debts to CRAs, that's just an abbreviation for Consumer Reporting Agency or Credit Reporting Agency, is one of the most commonly used arrows in the debt collector's quiver. And then this case also cited a couple of district courts, that's the trial court cases. We've got this JBC legal group. Let me just highlight this. When verification request has been sent, all further attempts to collect on a debt, including any subsequent, so that would not necessarily include prior credit reporting, but any subsequent reports to the credit reporting agencies violates the law. Here's this Unifund case. Reporting a disputed, unverified debt to a CRA, again, that's like Equifax, Experian, TransUnion, without designating the debt as disputed violates the law. And then the court here in this Rainmaker case says, I understand that there are some different cases. So here's one from Kentucky and one from Southern District of Florida. But The case that this judge is relying on pointed out that neither Breed nor Jackson provided much analysis. And the court says, you know, you've got this FTC letter, that it's a tool, you've got this sort of quiver in the arrow, and our judge here says it's well-founded, this observation. And here's kind of the conclusion of it. Credit rating is extremely important to consumers and can affect the ability to obtain credit, the rate of interest on loans, even insurance rates. The reporting mechanism can thus pressure the consumer to pay the debt, perhaps to an even greater extent than a letter or a telephone call, and it serves the same purpose. In practical terms, and in view of the liberal construction owed to remedial statutes such as the FDCPA, this is an attempt to collect a debt. So let me say this, and I've been suing debt collectors for more years than I can remember right now. Think about it this way. You get a collection letter. So what? I mean, you can throw it away. It doesn't harm you. Okay, now, if it violates the FDCPA, it may cause you emotional distress and things like that. But just the letter itself, you can throw it away. They call you. You can let it go to voicemail. You can block the call. Okay, again, that can be annoying, but here's where I'm going. What has the greater harm? Let's say you're in the process of buying a house or qualifying for security clearance or anything involving your credit, and all of a sudden this collection account pops up. Well, that may keep you from getting the house or getting the apartment or getting the security clearance or getting the job. Now, just having a letter or a phone call, you know, that doesn't get factored into your FICO score, okay? Your security clearance doesn't say, oh, you got a phone call, we can't give you a security clearance. So what the judge is saying here is true, and I would say the general rule is credit reporting is a lot worse than making a call or a letter. Now, there are certainly outrageous calls and letters that do just as much harm as outrageous credit reporting. But the point is, it is absolutely an attempt to collect a debt, which is the summary here. It is an attempt to collect a debt. And so the judge says, let me highlight this. I find that when the collector reported the debt to Equifax before verifying the debt, it violates 1692GB, and permitting plaintiff to amend his complaint would not be futile. And so the question that will be for the jury is the debt collector entitled to this bona fide error defense? And so that's what the court did. The footnotes can often be interesting. Different judges do it different ways. This particular one, it's a lot of the quotes from the statute will be put in the footnote. So this is under 1692E, saying don't use false, deceptive, misleading. And here's an example, this E8. Communicating or threatening to communicate to any person credit information which is known or which should be known to be false, including the failure to communicate that a disputed debt is disputed. And then here we have under disputed debts, this is under 1692G, if the consumer notifies the debt collector in writing. Now you can do it verbally, but you don't get quite the same benefit. Or if you do it outside the 30-day period, you don't get quite the same benefit. But this specifically is within that 30-day period. And if you tell the debt collector in writing that the debt is disputed, and that can be and or, okay, or you request the name and address of the original creditor, the debt collector shall cease collection of the debt or any disputed portion thereof until the debt collector obtains verification of the debt or a copy of the judgment. So let's kind of go back to this, because this is that fundamental basis here. So you tell the debt collector, I dispute the debt, and or you tell the debt collector, I want the name and address of the original creditor. Then let me just highlight this, and the court has put in italics to emphasize that the debt collector shall cease collection of the debt. That's why we had to figure out if reporting to credit bureau is collecting debt, which it is. Shall cease collection of the debt or any disputed portion there until the debt collector obtains verification of the debt or a copy of the judgment or the name and address of the original creditor, and that's sent to the consumer. So that's the case here. I hope that you found this helpful. As I always do, I'll put the link, the Google Scholar link, in the the description of this video. And so you should be able to just click on that. You can also search it. It's got up here, Ewers, I guess is how you pronounce it, Ewers versus Rainmaker Recovery 3, the number 3 Inc. And I suspect there are not many cases against Rainmaker since it's such a small outfit. And if you have any questions, or you're in a situation where you are thinking about sending a validation letter, or you have sent it and maybe the collector is reporting, is updating the credit reports after you've sent the letter but before they actually verify the debt, then definitely get that checked out. You can always reach out to us or reach out to another consumer protection lawyer, but find out your rights on that, because when these guys get sued and it costs them money, that's what will ultimately change. They're not going to change because it gives them a warm feeling in their heart to do the right thing. They're going to change because they've been sued and they've had to pay you money, they've had to pay their lawyers money, and they have to pay your lawyers money. That's what will ultimately get them to change. So thanks for watching this, and I will catch you guys in the next video. Bye-bye.